ballot. And as to the small precinct question, as you pointed out correctly, Your Honor, from the cast vote records, the cast vote record identifies what precinct the votes are from. So you would get to the same result, and they'd be willingly given it. So we would, again, just simply submit that what the county is trying to protect is outweighed by the public's right to know.
Okay, let me ask Mr. Drewowitz a question, which is, if somebody is concerned, legitimately concerned, that these machines aren't doing what they're supposed to be doing, that they want to know how sausage is made, right? Many people don't want to know how sausage is made, but they want to know how sausage is made. And they take pictures of these things and they count these images. How would they ever be able to get that information? And are they entitled to that information? I mean, as a citizen of our state, they may want to know that there's some integrity in these machines so that the votes are being counted appropriately. With these statutes in place and with the ruling that you want me to make, how would they ever get that information? Or are they not entitled to it?
Your Honor, there is specific case law that says they're not entitled to get to see how the sausage is made in an election case. Just because you're interested in making sure that and we cited it in one of our responses, that you're not entitled to just get to recount just because you want to recount. You actually have to go through and allege that there was one of the particular violations and then go through that particular, an authorized method by the legislature to do this. The legislature has created a very comprehensive scheme for how to verify that these things are working accurately, including the Secretary of State comes down prior to every single election and checks out the equipment, makes sure that it runs a test step, makes sure that it's tabulating accurately. At the end of the election, they were concerned that we weren't tabulating correctly, that the electronic results would match up with the paper results, so we got a hand count statute where we would randomly pull a number of different precincts. And Pima County does double the minimum required by law of precincts that we hand count. We go and we pull out those ballots and we match them up to the tape totals, so that we find that they're within the margin of error. And if there's an error, it's almost always human error in counting the ballots. So there are ways to verify that the machines are tabulating accurately. And as we cited, in I don't know how many years is it, 10 years approximately since we've had a hand count, for every single election we've held, none of our results have been outside of the designated margin.
And what is the designated margin?
It changes with each election depending upon the number of votes.
And what
that's all set by the state.
And what if the margin of error is smaller than the margin of victory? Is that factored in there?
There's an automatic recount statute that controls for that.
So your answer to how sausage is made has got to be done within the context of a recount of some sort.
There is very specific provisions. You get to see. You have a camera into the tabulating room to see. You can watch on the internet.
But you can't watch inside the computer.
You cannot. But that program, we ship that program off to the Secretary of State so that the Secretary of State has access and can verify that it works properly. They come down and verify that the machines work accurately. There are a whole host of protections that are provided for in Arizona law. This is not one of them.
I would just submit to Your Honor that one of the wonderful uses of the public records statute would be an academic, for example. When we're talking about an activist group, I just want to put this out there. The public has a right to know that, and what the county is saying is, well, the Secretary of State verifies it. That doesn't help the public's right to know. And we submit that the public, under the public records statute, has the right to know how they go about performing their job. And as long as the individual's identities are protected, there's nothing to protect, and we don't have Washington State.
Okay, I will tell you that I am concerned about the secrecy involved in elections, but maybe that's just part of the process. I mean, it's statutory, it's part of the process. And I think my concern lies more with not secrecy in the process, but secrecy in the machinery. I mean, it sounds almost like a Robert Ludlum novel. I mean, there's certain things that could or might happen that we may never know about, And it bothers me that there's no sunlight on that part of it, and it's all within the context of the state, Secretary of State. That's what bothers me. And I don't know that that there have been a lot of cases that flesh that out. On the other hand, I'm not supposed to be looking at what somebody wants to do with the material, how important it is to the other side, because that's sort of a presumption. It is a presumption that there should be sunlight on the other side. So I'm going to take this under advisement. I'm going to look at cases again. I'll get you out of ruling as quickly as I can. It's not a very complicated one because I've thought about it a lot. For now, I'm denying the other motion without prejudice as to the discovery issues. So I'm denying all of the motions in this case without prejudice, subject to my ruling in the context of the motion for judgment on the pleadings. Do you have anything else that you want to add? Either side?
Your Honor, just to very briefly answer plaintiff's counsel's arguments, the interest that Pima County is pursuing here is to follow the Constitution, to follow the state statutes, to ensure the finality of election results and the confidentiality of the votes.
And one of the answers may be is if the legislature is spoken and you don't like the way the legislature is spoken, you may have to go to the legislature and change the law. I don't know. I need to follow the law, whatever it is, and figure out whether these records that I found to be public records are subject to disclosure under Carlson and the related law. Okay. Does everybody agree that's the issue?
That is the issue.
Okay. Anything else that we need to do today? Okay, we're at recess. Thank you. Matter under advisement.
I refer first to the need for far greater public information, and second, to the need for far greater official secrecy. The very word secrecy is repugnant in a free and open society, and we are, as a people, inherently and historically opposed to secret societies, to secret oaths, and to secret proceedings. We decided long ago that the dangers of excessive and unwarranted concealment of pertinent facts far outweighed the dangers which are cited to justify it. Even today, there is little value in opposing the threat of a closed society by imitating its arbitrary restrictions. Even today, there is little value in ensuring the survival of our nation if our traditions do not survive with it. And there is very grave danger that an announced need for increased security will be seized upon by those anxious to expand its meaning to the very limits of official censorship and concealment. That I do not intend to permit to the extent that it's in my control.